Thank you for joining us today for our presentation with Attorney Christina Lesher. I am Allison Scarborough, Consolidated Planning Group. We are a special needs planning firm. Some of you that are joining us are new to us today, and some names I see are familiar, and you attend a lot of our Zoom meetings, so thank you for being with us. Consolidated Planning Group is a special needs planning firm, and we really focus and specialize on holistic planning for special needs. There are a lot of there's a lot of considerations that come into play when it comes to special needs planning, and a lot of it goes back to preserving, state and federal benefits for your child in the future. So the topics that we discuss are over a wide range of topics. Sometimes we talk about guardianship, we talk about special needs trusts, we talk about ABLE accounts and letters of intent. There's a lot of buzzwords when it comes to special needs planning. But so we're here, and today we are excited to bring the law firm of Christina Lesher. She is probably not a stranger to many of you. This is probably a name that you guys have heard a lot in the Houston area. She's kind of like the mother of special needs attorneys in the greater Houston area. So we're super, super excited to have you here with us today, Christina.
Oh, thank you.
I'm really going to just turn everything over to you. Everything today is being recorded. We will send out an email with the recording after this. So if anybody has to jump off, you will get this. And then also, as we're going through this presentation today, if you would just take the time to put your questions in the chat box, we're going to get to just as many questions as we can. And we also plan for this meeting to end by 1 o'clock. So if you're trying to plan your calendar, just so you know that. So thanks so much. And Christina, I'm turning it over to you.
Thank you so much, Allison, for having us today. So I just wanted to introduce myself to everybody. My name is Christina Lesher, and I'm a special needs and elder law attorney. I've been practicing law for 17 years, and before I went to law school, I was a social worker for an attorney's office that did special needs and elder law. And I went to U of H Law School, and I have a degree from Texas State in social work. This type of planning is very personal to me. My sister has a medically fragile child, and I did not start my practice because of him, but he's definitely influenced the trajectory of our office practice, and definitely has increased our understanding and knowledge and appreciation for the amount of work that needs to be done to plan for a family member that has special needs. So I'll get started with a few things. I hope everybody can see our PowerPoint. I'm a huge PowerPoint person. And all this information will be available for you after our Zoom webinar today. So thanks to Consolidated Planning Group for having us. And there's a little bit of information there. There's my information. If you're a Facebook person, you can see updates. There's our website and Twitter account. So planning for a loved one or a child with special needs, some of it is just regular old estate planning that parents and families need to do. So I have what I call the top 5 documents. Number 1 is a will or revocable trust, or both. By the way, we're going to go over these in some detail, so take as many notes as you want, but this is kind of like our overview slide. We have a third-party trust, a first-party trust, documents for incapacity, and by documents, I mean the documents for the parents. So many times parents, as we're taking care of our children, we forget that we have to plan for our own incapacity. Death is a part that we all know. The tricky part sometimes is if we become incapacitated, especially if a special needs child, we need to make sure that there's someone there to help make decisions for you as well. And then something that Allison and I have talked about, we were both very passionate about beneficiary designations. I dream about beneficiary designations at night. I spend a lot of time counseling clients. I know Allison does too. And we know that beneficiary designations can make or break an estate plan. And so just for everyone thinking about beneficiary designations, that's when you have an account such as life insurance or some type of investment account, you want to make sure that when you die, it goes to the right person or to the right trust. So we'll talk about each of these bullet points in more detail, but those are our top 5 that we're going to discuss today. Okay. So most of the times when the families come to see me, they come in, they say, oh, I've got kids, I've got a daughter or son with special needs trust. I need a will. I have to have a will. Do I need a will or do I need a trust? And I'm going to tell you the lawyerly answer is it depends. Okay. So both do the same thing. A will and a revocable trust send your money where you, or your assets, where you want it to go when you die. Now, a couple of things we need to know, and this may be information you already know, but when you die, the law divides the things that you own into 2 different categories. We have a probate and then a non-probate. So I always use myself as an example. I have a life insurance policy. I've named my husband. So if I die, my husband gets, $1 million, and I always joke, in a new girlfriend, but that's okay. That's okay. She'll earn it. We have 2 wild children, so she'll earn every penny of it. So if I die, he gets money. He's on the beneficiary designation, listed as the owner. That's a non-probate asset, meaning he doesn't have to go to court to get this money. Our house that we own with Wells Fargo, right? That would be an item that would have to go through probate, meaning he would have to go to court and change the title out of my name into his name only. A will is a legal instrument that's used at probate, meaning when someone dies, then you have to take that will to the court and go through the legal proceedings. Here's the good news. In Texas, and if you move to California or New York State, that's not going to be the case. But in Texas, if you have a will, it's a fairly easy process. Now, remember, the will is effective at your death. So if you have a will and you think, oh, I don't need a power of attorney for my spouse because I'm married and I have a will, that's not true, because the will only becomes effective when you die. And in Texas, by the way, you have 4 years from the date of death to probate a will. Okay, so that's just a little note that you may want to add. In your will, you can do all different kinds of things. So it's frequently that parents will name guardians for their children. It can also contain a supplemental needs trust, what we call a third-party supplemental needs trust. And just for a little short note on that, and we'll talk about this more here momentarily. But remember, a third-party supplemental needs trust is that type of trust that is set up and funded at death, or the money goes directly to the trust, and therefore there's no payback provision to the state of Texas. And you can also have trust for siblings or other family members that are minors. So in my estate plan, I have a will because I have a fairly simple estate. I have trust for my children, and then I have a supplemental needs trust for my nephew. My will only becomes effective at death, and my will only controls those things that are in the probate estate. So it does not control a retirement account or a life insurance policy that has a beneficiary designation. Okay. Revocable trust, it is effective when you sign it. And it can also contain a third-party trust. It can also have trust for children, family members. Keep in mind that these revocable trusts, I kind of compare them to like a cereal bowl. There's certain things that we put in it. For example, you would put your house in it. You may put a bank account. We typically do not put IRAs or life insurance for tax purposes. If you are thinking about who's going to manage a trust for your special needs loved one, I will typically recommend a revocable trust if you're thinking about a professional trustee. We call them corporate fiduciaries. For example, you may have a lot of people in your family that you like, but you may not trust them with money. Is it just me? I may be the only person that has people like that. I love certain members of my family, but they're not good with a checkbook. They're great people, but they don't need to manage assets. Or I may only have a short list of people that I trust, because we say in our firm that a trustee or someone who's going to handle your money either during your lifetime or at your death has to have what we call the 3 T's. They have to have time, they have to be trustworthy, and they have to be talented. And there's one more element, they need to be immortal. And since no one meets all 4 of those criteria, we sometimes think about a corporate fiduciary or a bank to handle the money at some time in the future. And because those banks, especially for special needs trusts and for special needs kids, they prefer to handle those trusts within a revocable trust. I think it gives them more comfort that they're able to access it immediately rather than having to go through the probate system. They will still handle a trust if it's in a will, but as we'll talk about later, these corporate fiduciaries have certain minimum requirements. So you can't have $1,000 and want a professional fiduciary to take care of it. They're going to want a certain dollar amount. We're typically looking at anywhere from 1 to 5 million. You may be thinking, that's a big number. There's no way our assets are ever going to be that way. That's when you go back to Allison and talk about life insurance. Because that way, if you ever run out of the trustworthy people in your life, if you have a life insurance policy or some other type of financial product that will generate that asset, maybe not during your lifetime, but at your death, then that's a nice way to have an option as a corporate fiduciary at a later date. Now, let's go back to the question of, do I need a will or do I need a trust? I think if you're a KISS person, which is keep it simple, sweetheart, I would do a very simple will. If you're working and you just want to get something done and 10 years from now, you may want to do something different and you want to just do kind of a basic, what I'd call Camry model, you want a will. If you want to do more extensive planning where even if you're working, you're busy, you have kids, but we really want to just do this once and get it done right, I would suggest a revocable trust. The revocable trust takes more time for lawyers, more time for you, and therefore is more expensive. The will, remember, that's what I have. I could draft a trust for myself, but I'm a busy working mom. I know I'm going to coordinate everything with the beneficiary designations. I have a will. So it depends on what kind of mindset you're in. Now, if you have out-of-state property, especially if it's in the state of Louisiana, you are going to want a revocable trust. Now, if there's anybody here from Louisiana, I'm not speaking ill of your state. It's a great place to go and visit, but you don't want to die in Louisiana without a will or without a revocable trust because they have very funny laws about how money is supposed to be distributed. And if you die in Texas and you own out-of-state property, you may have to go through a legal proceeding in both states. You don't want to do that. You want to keep it nice and easy for your family. So if you have real estate or you may own real estate in Texas and in another state, I would suggest a revocable trust just to keep it nice and simple. If you have a revocable trust, guess what? You still need a will. And as we say on this little PowerPoint, we need what we call a pour over will because sometimes we accidentally don't fund a revocable trust all the way correctly. The example I like to use is, let's say the day before you die, you inherit a piece of property. You didn't have time or notice that you were going to have this property and it was never transferred or deeded or titled into the name of your trust. Then what the pour over will does is just what it says. It pours it over into the trust. You still have to go through probate, but it's a lot less of a legal proceeding, a lot less time and hassle and expense. And again, you're going to hear this from me a million times. Carefully review those beneficiary designations. If nothing else, and I love Excel spreadsheet, have an Excel spreadsheet, document every single asset you have, even if it's the life insurance policy at your office that you think you don't really care about, you pay $1 a month or something, that even that asset without proper planning can seriously disrupt the planning we're going to do for your child. Okay, so sure.
Christina, I just want to chime in here, because you've said a lot on the slide and it's really, really good. One thing that I want to reiterate with everybody on here, we hear people say, yeah, I've made the beneficiary in my will such and such. They get everything. And there's like a little bit of a misconception out there that if you have this will and you have named this person in your will to get everything, that it is literally everything.
Right.
But it's not. The beneficiary designations on a life insurance, annuity, 401k, any type of your investment accounts, that is who's getting the money.
Exactly.
So regardless of what the will says, and if the
Yes.
will was done after you did your beneficiary designations, the beneficiary designations is who gets it.
That's right.
So there's 2 steps, and I just want to make sure everybody knows that, for that. And then two other quick things. That one thing I usually mention in the beginning is why would anybody on here need a special needs attorney and a special needs planner, and the differences. And basically, I like to summarize and say, Christina is the paper. These are the legal documents. You must have these. These are important. You have these in place, and we're the money. We're the funding. So she talked about like funding some of these things, and reaching back out, whether you are independently wealthy and you have millions of dollars, or you're funding a trust upon your death with life insurance. A special needs planner is the funding, they're the paper, and we make sure that the money is in those right buckets, and those buckets are set up by the paper. So that's why you might need both, and there's seems to be some confusion on that. Could you just share before we go on to the next
Sure.
slide, when it says some assets are placed into the trust,
Yeah.
not IRAs or life insurance, can you
Right.
tell them why?
Yes. Okay. So that's a good. Okay. So the revocable trust. Here, I like to use examples. If you're in my office, I would have a bowl of chocolate because I have a sweet tooth, and I like to show examples. So this is my revocable trust, my little coffee mug, right? And here's my house. This pen is my house. I, by deed, transfer the house into my trust, and it's done with either a deed or paperwork done with a bank. So to answer Allison's question, we typically do not put IRAs into revocable trust because then it becomes a taxable event and you pay the IRS a bunch of money. We don't want to do that. What we want to do is on the IRA, maybe you say everything that my IRA goes to my husband. And then if he fails to survive me, then it goes to the trustee of the Supplemental Needs Trust established for your child's name. But you don't want to put an IRA into a trust because we have to pay the government. And typically for life insurance, most of the time, I believe there's some type of contractual prohibition on that for some types of life insurance policies. And we just name the beneficiary designation, meaning you name your spouse and then the trustee of the Supplemental Needs Trust for your child. And on the life insurance and on the IRAs, it's, by the way, when we talk about funding, it's not an all or nothing. So you could chop it up. You could say, I have a $100,000 life insurance policy. It all goes to my spouse. If my spouse doesn't survive, then 70% goes to my child with special needs, 30% goes to the other children. Because that's the other big question that we're not going to answer today because you're all different families with different dynamics and different needs. You don't have to have an all or nothing thing. And so the big question we have, especially if there's other siblings or other family members that may need money when a couple passes away, is how much does that child that's on Medicaid need? And that's a question that is sometimes a conversation between the family, and sometimes a conversation between an Allison person and then an attorney person. And you may say, listen, we're going to give in our estate, we're going to give everything equal shares. So our house, everything, bank account, so forth. And then maybe you purchase a life insurance policy separate and apart that's only going to a supplemental needs trust for a child. Now we're kind of getting into the weeds a little bit. So I'm sorry if I'm, Allison, if you ask a lawyer what time it is, they tell you how to build a watch. So that's kind of where I feel like we're headed. So I'm going to pull back a little bit, but be careful when you do the revocable trust that we don't put things in it that will cause you tax problems. And instead we use beneficiary designations to direct where that asset goes into correctly at the time of your death. And by the way, we're going to talk about it here in a second. Even if you are married, even if you've been married a very long time, everybody needs a financial power of attorney. If you are over the age of 18 and have capacity and the ability to have a power of attorney, you need one. Okay, so we'll talk about that more later. And I mentioned that just because IRAs especially, there's some confusion where if I'm the beneficiary of an IRA, then I can control the IRA if my spouse becomes incapacitated. That's not true. So I have an IRA, my husband is the beneficiary, but that doesn't mean he manages it if I get sick or become incapacitated. So what I've done is I have a financial power of attorney. I've sent it to the financial institution that holds my IRA, and they've already had to give its pre-approval. I will tell you this again in a future slide, but just we're here. Okay. Allison, anything else I need to add? Okay. All right. And again, please, if nothing else, review those beneficiary designations. And so we'll go on to the next slide. Okay. Why do we need a supplemental needs trust? We get this questions a lot. Most of the time, families come to me because their child or their loved one is on Medicaid or is anticipating Medicaid eligibility in the future. And as the slide says, by the way, there's over 109 Medicaid programs in the state of Texas, and they all do different things. They all have different income, asset, eligibility, medical requirements, different policies on if you give money away. So this is why it is what we call a bramble bush for families to figure out. The fact that you showed up at the webinar today tells me you have done some kind of research. And if you heard Allison, I don't know if it was the last program, but the program on waivers that you guys did it before the end of the year, that was fantastic. That there were things in there, my whole office watched it. And I will tell you, there were things we didn't know, of course. You know, we learn something new every day. But that's why these Medicaid programs are so important, so precious, is because they all have such different medical requirements, interest lists. Most people know that for most Medicaid programs, their children cannot have countable assets that exceed $2,000. There are some Medicaid programs where that rule is different, but it's typically when you get older, okay, and are married. So when we think about countable assets, it's typically cash, bank, second home, second car. Exempt, that's considered $0 by Medicaid. That's a homestead, personal items, car, and clothing. So if they were to inherit directly from you, meaning if the assets are not put in trust, then it may financially disqualify them for these very precious Medicaid programs that pay for healthcare, housing, family support, and so forth. The other reason why we do supplemental needs trust is maybe we have an individual that can't manage their own money or maybe at risk for financial exploitation. So we typically counsel with clients from a variety of asset levels. We have clients that have maybe $500 to their name to clients that are extremely wealthy. And the extremely wealthy clients say, why do I need a trust at all? And I'm thinking, well, sometimes we need a trust just to protect us from being financially exploited from other people. And that's what the supplemental needs trusts do, because in order for the supplemental needs trust to be considered a supplemental needs trust, the beneficiary or your loved one, your child with special needs, they can't manage it, meaning they cannot be their own trustee. Okay. One thing I want to make a note of, and the fact that you're showing up here today tells me that you probably already know this, is that you do not have to disinherit your special needs child, meaning you don't have to say they get nothing so that you don't disqualify them. That's kind of a myth or a rumor that you should just say nothing goes to them. Sometimes parents come to me and say, well, I have a very trustworthy daughter and I'm going to leave her all my estate and I know she'll take care of her sister. I think it's a terrible idea because you don't know what's going to happen. She might marry somebody in the future and get divorced and all that money goes in the divorce. Or she may be in, let's say, a little fender bender and she gets sued and there's a judgment against her. These funds are not going to be protected. So not only are you protecting the funds for the future use of your child and not disqualifying them for Medicaid and not putting them in a way that the special needs child may be taken advantage of financially, you are protecting them from creditors. So it's great if you can have an individual member help manage assets, but we want to make sure that we put the right person in at the right time. So the supplemental needs trust are sometimes also called special needs trusts. Some states, there's a differentiation. Texas is not one of them. And to make it really confusing for everybody here on the phone, on the webinar, I might use them interchangeably. I'm sorry, that just is kind of what happens. Okay, so why do we need supplemental needs trust? Is so that you can leave money, or other people can leave money to your child in a way that's not going to disqualify them financially. But remember, we still have the income test, transfer policies, medical and disability requirement as well. Okay. So I want to start out with a third-party trust. This is our preference. This is a trust that is created either in your will or outside of your will. And you go through and you work with Allison and I, you make sure the beneficiary designations are perfect. You map out that beautiful Excel spreadsheet. You take your life insurance beneficiary designations, you update it so it's payable to the trustee. You get that letter back from the financial institution that says, yes, we've updated your beneficiary designations. Everything looks great. Now, that's what we want to have done. These trusts can be established by anybody. I could establish a supplemental needs trust for Allison. She could do one for me. There's no requirement for that. The trustee can be anybody but the beneficiary. And there's no payback to the state of Texas, meaning for my supplemental needs trust, for my nephew, who his name is James, by the way, if James dies, then it goes back to my other two children, Luke and Max. They will inherit their cousin's share should James die, okay? There's no payback to the state of Texas. That's a big myth. Oh, I don't want a supplemental needs trust because when my child dies, I don't want it all to go back. That is not the case with this. This is why it's so important to make sure that we do the funding correctly now. You can name alternate beneficiaries, as we talked about, and this is reviewed with less scrutiny by Social Security than what we call first-party trusts. And the first-party trusts are those trusts that are funded with the Medicaid beneficiary's own assets. I have seen third-party trusts where we will sometimes name multiple beneficiaries. I think that's a little convoluted for families and hard for the trustee to figure out how to make distributions. So I typically say, if you've got more than one special needs person in your life, they each need their own supplemental needs trust. It will help keep the trustee out of trouble and from breaching what we call their fiduciary responsibility. Okay, Allison, anything I need to add to that?
I'm thinking continue. What we do here a lot, I think you're just going to go through this.
Okay.
There is always a lot of confusion on a first-party trust versus a third-party trust and the Medicaid payback versus not.
Yeah.
And I think that we throw this around all the time because we do this every day.
Yeah.
But there's people on here for sure that don't know the difference between a first party and a third party.
So, for example, third-party trust, that's a trust that we establish now. Let's say if you have a life insurance policy, it gets paid directly to the third-party trust. And the money that goes in it is money that does not belong to the Medicaid beneficiary. They never have ownership of it. Now, let's say that happens. From time to time, we have things that happen. It's not unusual in my office for somebody to be on Medicaid and then they get a call and maybe the parent has died and maybe the mom and dad are divorced and maybe one parent has died without a will. And now we have money coming to an individual who is on Medicaid. That could be a problem. Maybe we have a situation where someone's working, because on a lot of these programs, you can be on Medicaid, you can be on SSI, and you can work. You just can't work too much. Maybe somebody has a small personal injury, but it's money that belongs to the Medicaid beneficiary. These trusts are carefully reviewed by Social Security and Medicaid, and it has to meet the following requirements. So the person who establishes the trust, and that's called the grantor, has to be a parent, grandparent, guardian, or court order, or under the S&T Fairness Act of 2016. Now, a beneficiary, if they have the capacity, can be their own grantor. They cannot be their own trustee, but they can be their own grantor. It's such a funny word, grantor. What does that mean? It's like when you have a party. Sometimes people have party planners, right? And they set everything up, and then everyone comes, and the trust is kind of like that. So the party planner is the grantor. They set it up. They say, here's a legal instrument that I want to establish. That's what a grantor is. Sometimes it's called a settler. We do this to make it, lawyers do this to make it confusing to the public, but it's nothing fancy. Y'all can get it. It's just the person that signs and says, I'm setting this up. That's the grantor. The person that controls the money, that's the trustee. And the person that gets to use the money, that's the beneficiary. And for a first party trust, we cannot have the beneficiary be the trustee. It has to be somebody else. The beneficiary uses his or her own money, maybe from an unexpected inheritance, maybe from work proceeds, maybe from a small personal injury. And a lot of times we will also use these first party trusts for child support cases where child support is causing someone to lose eligibility for SSI. How the money comes out is very specific. The money has to be used for the sole benefit of that beneficiary. And you all seem like you're logical, rational people, and with sole benefit, yeah. This in the past has been one of the most heavily litigated issues in Social Security. Because if you live with your parents, maybe the parent wants to use the money in a trust for a car. Well, obviously, mom's going to drive the car because maybe the kid can't drive or the kid's a minor. Now, if mom drives the car and the kid isn't with her, is it now violating the sole benefit rule? Lawyer stuff, right? But typically, if you use it for things such as entertainment, clothing, educational expenses, therapy, you're going to be what I would call the safe harbor, where things get tricky and we have to document things. I'm not saying that you can't do it. It's vehicles, vacations, and so forth. The good news is that Social Security has gotten a lot more relaxed. About 5 years ago, they were really uptight about this whole sole benefit rule. It caused a lot of problems for families, but the good news is the pendulum has swung the other way, okay? Now, the assets have to be placed before the person, the beneficiary, and by beneficiary, we mean the person who is receiving Medicaid benefits before they turn age 65. Not when the trustees turn 65, but when the beneficiary turns 65. So in my example, my nephew James, if he had money in his name outright, then we would have to put it in there before he turns age 65. Now, at the death of the Medicaid beneficiary, meaning the person who's on Medicaid, when they die, any money that's left over may be subject to repaying Medicaid to the extent that Medicaid paid out benefits on their behalf. And if they've been in multiple states, you have to figure out which state had the biggest claim, and we would do what we call a pro rata, meaning if whoever had the most money out, they get the most repaid back to them. Now, this payback provision is only for the trusts that are funded with the person that's on Medicaid, their own money. So let's say that we have a first party trust and the parents, you guys have spent it on summer camps, you've done everything, and then tragically this person dies. Then if there's no money in this first party trust, then there's nothing to pay back to Medicaid, and they can't go look at the third party trust to get paid back. They're subject only to the money in that first party trust. If there's money left over, we can name backup beneficiaries. But these trusts are the most heavily scrutinized, especially by Social Security, SSI. They have now set up regional offices to review these trusts to try to make sure that the approval process is more uniform. And by the way, if you receive money and your loved one is on Medicaid or Social Security, you have 10 days to notify Social Security and Medicaid of this change of status. You can't just say we set up the trust and not notify Medicaid. They want to know. They have to be told yes. So a lot of times families will say, can I establish this trust, not put anything in it, and then have Medicaid review the trust? They will not do that. They used to do that, but they don't do that anymore. A lot of times families will notify Medicaid, of these trusts, and we never hear back from Medicaid. Sometimes we do, sometimes we don't. Even with their new processes, it's still not a perfect system, and you don't necessarily get a letter back saying everything looks good. And the other problem is on these first-party trusts, because a trust has been approved in the past, doesn't mean it will always be approved. So that's why we have to be very, very careful when we are drafting these trusts, that we do not use old forms that we find on the internet, or we go to somebody that does not do this on a routine basis, because this is a really good way to lose eligibility and cause a lot of problems for yourself.
Christina, there's just two things on here that I would like to chime in on. First,
Okay.
you just hit it, and I say this, people that have been on our Zoom meetings over and over again, they could probably like quote me on this. Do not do it yourself. Please don't do it yourself. And please, please do work with a special needs planning attorney. It's so super important. There's a lot of attorneys out there and a lot of brilliant attorneys out there, but they're not always brilliant about special needs. I mean, this is a specialization where people really understand Medicaid and SSI eligibility, all of these other things and these other programs. And so that's why it's so super important to work with somebody that's, specially trained. And then the other thing that I wanted to hit on, and hopefully nobody on here is in this situation from a divorce perspective, but we see a lot of your average divorce attorney doesn't really have any background at all in special needs, and they accidentally mess you up and don't get your child support for your special needs child directed to a first party special needs trust. I've recently heard someone say, "Oh, it's no problem. I just went into the Texas child support, and I just simply redirected it to a trust." And so, yes, you might be able to change the bank account of where child support is going in the Texas system, but it's a lot more complicated than that. It's not that easy. You do need an attorney. You do need a first party, special needs trust. There does need to be an order directing that child support to that trust. And it's a little bit confusing. I hope you're not in that situation, but just know if you are, you need to seek professional help about this, because this definitely can and will cause your child to either be disqualified or never qualify for benefits. It's really, really important. So I just wanted to hit on that. We see it all the time, Christina.
Yeah. And we see divorce attorneys that unfortunately I think they think that works. And then part of that big missing piece is the notification to Medicaid and Social Security, because you definitely do not want to commit fraud. Okay. So let's think about documents that you need for incapacity. So we think a lot about death when we do our estate plans, and it's because it's all triggered a lot of our decisions on when are we going to die. And there's, I guess you call them actuaries, that will figure out how long you're going to live. But for you, and then maybe for your child, you need financial powers of attorney. So what I like to do with the financial powers of attorney is send all of them to every financial institution that I have an account at, especially IRAs, because you don't put those into a revocable trust for tax purposes. So get that financial power of attorney for you and your spouse. I like to have the financial power of attorney effective upon signing. You're going to want a medical power of attorney for you. You're going to want a HIPAA release. And the HIPAA release is just a list of people who can access your medical information. And on your HIPAA release, because your financial power of attorney may be needing to speak to your insurance companies, I would say if someone's going to be in charge of your money at any stage of your life, they need to be on your HIPAA release. The directive to physicians, that's what would control your decisions at end of life. An appointment of guardians may be for yourself and your child. Typically, we do appointment for guardians, especially if we have someone in the family that we never want to be in charge of our medical or finances. And then we can specifically exclude them from ever going to court to try to become our guardian. And maybe you want an appointment of what we call disposition of remains. That is where you're, what kind of funeral you would want to have. And then medical study for body or organ donation. That's very important to some of our clients. So let's talk about guardianship. Like anything else in life, it is going to be specific to your family. There is a lot of conversations that I see on Facebook and that I see in my office about you have to get guardianship. Let me go ahead and tell you the facts. You are your child's natural guardian until they turn age 18. After 18, you can do the guardianship at any time. You don't have to do it 12:01 the day that they turn 18. Maybe you don't want to do it. Maybe it's just not convenient or timing. Because of guardianship, it is a lawsuit. It can be expensive, especially if we have divorced parents. You have to have an ad litem, that is an attorney for your child, requires an annual review. And once you're under the guardianship, it is very difficult to get out. You can't hop in and then hop out, but you can always do it later. We see this most frequently when it comes to families who have children and they're in some type of special educational program. They go to the ARD meeting, and then at some point the child turns 18, and the school wants them to get guardianship. And the parents, for a lot of different reasons, personal reasons, maybe they don't want to be subject to under the jurisdiction of a court. Maybe they don't have the money to do it. Maybe they have other things that they want to do, or they just don't want to pursue this. Maybe we think about an educational power of attorney. Now, this is not recognized by Texas statute. I'm going to say it's a little bit the law according to Christina, but what I have done is I have taken a financial power of attorney in looking at what some other states have done. I have created what I call an educational power of attorney. Now, if your child really doesn't understand what's going on, I wouldn't have them sign it. Sometimes this will help ward off the school's pressure, because what they want is somebody who's authorized to sign the educational plan. That's what they're looking for. But you don't necessarily have to be guardian to do that. The other thing that families ask me a lot about is the supportive decision making. I think there's certain areas where it can be super helpful. And with the supportive decision making, it's kind of like an informal agreement between a person who's over the age of 18 and someone that could just talk to people on their behalf and go with them to the bank and go with them to doctor's appointments. For me, my thought is, if your child has the ability to sign a supported decision making, if they're willing to sign powers of attorney, which can be revoked at any time by that adult child, why not get powers of attorney for that person and maybe avoid having to do guardianship? So a lot of times my families will come in and I will say, oh, the school wants us to get guardianship, or the doctor says we have to get guardianship. It's not going to be a one size fits all at any time, and you can always do it later on. So maybe you don't really have a need for it right now. For example, we had a client who's very well taken care of by his mother and dad. He's very medically fragile. His doctors have known his mother and dad for years and years. He's on Medicaid. Mom and dad are controlling his Social Security as the representative payee. Because you may know that Social Security has their own way of handling Social Security. You don't have to go through guardianship to get Social Security. And so this child, he is well taken care of by his parents. The doctors all know his mom and dad. He does not have a guardian. but the parents are able to make medical decisions for them. Now, if that ever changed, then they may want to go out and get guardianship for their son. But at this point, because of a lot of different reasons, they've decided not to do that. Okay, I want to give like 10 minutes. I want to go over this last little slide here. Oops. Okay. Does it say updating beneficiary designations on y'all's slide?
Not yet.
Okay. We talked about beneficiary designations. I wanted to take one quick minute about that. We talked about the trustee being time, talented, and trustworthy. Updating your documents, I would say at death, divorce, or job change. Make it fun. So once a year, open that bottle of champagne, take out your estate planning documents, make sure you still like everybody that's listed. Maybe you don't like champagne, maybe have a Dr. Pepper or a piece of chocolate, but make it on a regular basis every year. And then reward yourself for doing an update, okay? Okay, I wanted to leave a few minutes to answer questions, or if there's a slide that I went over too fast or something like that, let me know.
Okay, so we have a question. Can the will set up a trust for sibling that is not a minor? Sibling is not special needs.
Yes. It can be done in a will or a revocable trust. Absolutely.
One thing that I heard in between the lines, but again, this is, we do this, we talk about these things all the time. We like we work with people that are they might be multimillionaires, and we also work with people that might be just starting out in their planning process. And when it comes to getting these things in place, like a special needs trust, for instance, or as you AKA a supplemental needs trust. You mentioned earlier that you could establish it outright, or it could be established upon your death. And that's one way that I like to share with people, is a cheaper way of establishing, like, so maybe you don't need a trust right now, but your life insurance is going to fund, future care for your child. The testamentary trust. So you want to talk about that for a second?
Sure. So I think it all goes back to the family. So the testamentary trust, testamentary, it just means of the body, meaning it's in the body of your will. So it's a cheaper way to do it because you don't have to spend as much time with me getting things set up. Okay, that's the benefit. The downside to that is you have to wait to go through the probate process. Okay, meaning you have to, which is not super complicated, but it may take several months. So if you've got a life insurance policy that is directed to a trust and a will, expect maybe a 6-month delay to get things set up maximum. Yeah, as long as everything there's no problems. Now, you may want to say, okay, I'm going to put a trusted family member on a bank account with a 6-month supply of overhead until this will get set up. Or maybe you'll give them a little bit of a slush fund to pay for things. But you need to think about, there's going to be a gap period between the death of the parent and if you have a will, when that trust will be funded. That's the downside. The upside to the revocable trust, having the supplemental needs trust, is that trust is already established during your lifetime. And so it's a quick turnaround when a parent dies to get the money from a life insurance paid out to a third-party supplemental needs trust that's in a revocable trust. But again, where you fall on this decision is going to be very personal to you. If you're a KISS person, keep it simple, sweetheart, and you know that there'll be enough cash in your estate or with other family members to get through the probate process, then do the will. If you think, I want to just button this thing up, dot the I, cross the T, and make sure that my child, by the trustee, has money the moment I die or relatively soon after that, then the revocable trust may be something you want to take a look at. But the revocable trust, definitely if you have out-of-state property.
And so one thing that we hear about is grandma and grandpa leaving their beloved grandchild money, and grandma and grandpa they accidentally don't know that it needs to be left to a supplemental needs trust. So one of the slides that you were on earlier, when you were talking about the important documents, I would just like to add of how important it is for you to talk to your family members and your loved ones, your parents, your in-laws, your aging parents about these things, because sometimes they don't know. And don't wait until it's too late, until it's a day late and a dollar short, somebody's had a heart attack or a stroke, they're incapacitated. But also talking about this delicate manner with your loved ones, because like mom and dad are really personal. They keep their cards close to their chest about what they're doing with money. We don't talk about this. This is taboo. One way to address this is, look, I'm addressing, a special needs planning for little Johnny, and I've learned some new things recently. We've put the following things in place. I'd like to share this information with you. But as I was doing this, I realized I don't know what your wishes are, or I don't know if you have this document in place. Are some ways to talk about it. But the biggest thing is to say, what I learned is if you leave little Johnny money directly, that it could, disqualify him for benefits in the future. But here's how I learned to do it correctly. And so giving them that information. So I know that we're almost out of time. We've got a few more questions.
Okay.
One person said that Social Security told them that they don't recognize the power of attorney, that they require guardianship. Guardianship isn't required.
No.
There is a form with the Social Security Administration that the individual, if you're not the designated payee, that the individual could authorize you. There's a specific form. I have that form. So if that is on file, then they will talk to you.
And just to bolster that statement, Allison, guardianship, it's not, the guardian courts do not have jurisdiction over Social Security.
Okay. So there are some workarounds with that. And so let's see, we've heard horror stories of guardianship, of strangers hijacking guardianship after parents die. Is this an issue that a sibling should be concerned about? Is this something that you've seen, Christina?
We see a lot of battles within families over guardianship. So maybe there's like a cousin that swoops in to try to control. I don't really necessarily see strangers in the guardianship arena, unless there's a family fight. If the family fights, then you will have a stranger or probably a lawyer who's going to get paid $500 an hour to administer this. So the best thing to do is to set up a trust. That takes the money away. Once money's off the table within either the hands of a responsible trustee or corporate fiduciary, typically a lot of these other issues with guardianship go away. But I would definitely do an appointment for guardian of your child and for yourself.
So let's talk about, so if I'm a guardian for my child, and let's say I literally have no other family members, okay, because I actually hear people say this, I have nobody else. Yes. I have nobody else.
Yes.
So there's no successor guardian appointed. How do I find a successor guardian? What about some of these corporate, like, Texas Bank or Cadence Bank? How do I find somebody else?
So let's kind of, and let's end with this question, because I want to give a lot of time to it, if that's okay.
Yes.
So we have to think about decisions for healthcare being different than decisions for money. So the guardian of the person would be the individual who's going to do the healthcare and where people live and housing. If you don't have people who can make those decisions, you need to reach out to a professional guardian. There are people in Texas that are professional guardians. There's not many. So if you're planning, now is the time to figure out someone in your life. Maybe they're not great with money, but they love your kiddo, and they'll fight, and they'll be that person that makes friends with the nurse at the desk of the doctor's office and make sure the kiddo gets an appointment ASAP. That's the kind of person that you may want to be for the guardian of your person if you can't. If you don't, if you absolutely have nobody in your Rolodex, then you need to reach out to one of these professional guardians. Now, on the call today, we have Robert Pierce, who is a care manager at my office, and on a limited basis, he will be a professional guardian. But I will tell you, the people that do this, I would say I don't trust a lot of them. It is hard, and it is going to be on an individual basis for the family. But if you are on the younger side of life, maybe now is the time to start cultivating a guardian of the person in your family. So in our family, I have 2 sons. I'm cultivating them to be guardian for their cousin. I'm not sure who's going to be on which side, but they will at some point in the future be helping their cousin out. So you have to look at who is in your family for the person. On the financial part, the best thing to do is to have a corporate fiduciary. Now, how do we figure out who's going to be the best? If you're on the younger side of life, meaning you're under 70-ish, I don't know if I would necessarily designate an individual right now. Allison, what I like to do on these third-party trusts is to appoint somebody that's called a trust protector. And what they do is that at the time of need, they look around and they figure out who's the best doing supplemental needs trust. Then they can either pick Cadence or Bank of Texas. I typically like a local trustee. I typically like a local bank or Texas bank. And I want something where no one's going to go to a call center. Like I want a person that I can sit with. But you may want to go in ahead and interview these people now to figure out how the fees work and what their minimums, because that will help maybe back into some numbers for you guys for life insurance and so forth. So think about a trust protector. You can pick a corporate fiduciary, and then that trust protector can also fire that corporate fiduciary if they don't like them, or demand accountings, or have some kind of control or seat at the table and be part of the distribution decisions for that person. Because that's what scares parents is, I don't want a bank in charge of making distributions. What if my kiddo wants something that's amazing? What if we want to go to Disney World for 3 weeks? I don't want a bank to tell me no when I've worked hard. It's my money. So think about a trust protector to appoint a corporate trustee so they pick the best one at the time of need. If you're 90 or you have significant health issues, and we think maybe you have a shorter life expectancy, you may want to go ahead and select a financial institution now.
That is really good. Thank you so much for explaining that. And it's kind of going back, and we'll probably do another one on guardianship with you, a whole nother topic. But the guardianship of the person and guardianship of the estate, and kind of explaining those differences. So thank you for that. Well, let me just check the chat. I think that we're really okay. So, okay, I think I have a few other questions, but it might be kind of an offline thing. So, Christina, you've been great. Clearly, you know what you're doing when it comes to this. If people want to engage your services, can you get them to your contact information on the end? Okay, there you go.
Yeah, so we have a website, lawlesher.com. The most up-to-date information is the Law Office of Christina Lesher in Twitter. As you guys may know, we're headed into a Texas legislative session. My office will be tracking all bills that may be related to Medicaid, healthcare, people with disabilities, and guardianship. So check our Facebook page for updates on the legislative updates. We will also be providing opportunities for families to advocate for their loved ones and additional resources. So this is a really important time for parents to be engaged with what's happening in Austin. They will listen to you more than me. I'm a lawyer, therefore I have no credibility, but you have credibility. So I will track those things for you and also provide some updates, and there'll also be PowerPoints and different videos. I'm a big PowerPoint person, so there's also old things that we've put it there on the Facebook page as well.
Awesome. Well, thank you so much, Christina. We really appreciate it.
Thank you, guys.
As I said, either later today or tomorrow, you guys, if you registered for this, you're going to get an email with the slides and the recording of this and our contact information. So thanks so much for joining, and I hope you guys have a great afternoon.
Thank you, Allison, for inviting me. I really appreciate it. Everybody stay warm. See you soon.
Take care. Bye-bye.
Bye.